St Basil's Home for the Aged in Victoria Proprietary Limited, ACN 0705111616, have pleaded guilty to one charge of failing to provide and maintain for employees, so far as was reasonably practicable, a working environment that was safe and without risk to health, contrary to Section 21 of the Occupational Health and Safety Act 2004, which carries a maximum penalty of 9,000 penalty units for a body corporate. The maximum penalty at the relevant time equates to $1,486,980. St Basil's has no prior criminal record. A prosecution opening was tendered on the plea and may be summarised as follows. St Basil's operated an aged care facility located at 24 Lawn Street, Fawkner, hereafter referred to as the home and the workplace. The home consisted of 147 single rooms and 3 double rooms with shared bathrooms. The workplace was divided into 3 sections, including a hostel with 54 beds, a nursing home with 72 beds, and a dementia unit with 24 beds. These sections were spread across 4 wings, which were known as North, East, South and West. The hostel was situated above the dementia unit. In July 2020, there were approximately 92 residents and 106 staff at the workplace. On 30 January 2020, the Director General of the World Health Organization declared the novel SARS-CoV-2 virus as a public health emergency of international concern. On 13 March 2020, the Communicable Diseases Network Australia, or CDNA, published the National Guidelines for the Prevention, Control and Public Health Management of COVID-19 outbreaks in residential care facilities in Australia. The guidelines focused on controlling the transmission of COVID-19 in residential aged care facilities. The CDNA guidelines set out information in respect to A, identifying COVID-19, B, routes of transmission, C, the persons at risk from COVID-19, D, the stocking and use of personal protective equipment or PPE, and E, the responsibility for ensuring that staff are trained and competent in all aspects of outbreak management prior to an outbreak, including the proper use of PPE, donning and doffing procedures, and the need for refresher training for existing staff. On 16 March 2020, the Victorian Government declared a state of emergency to combat the COVID-19 pandemic. On 4 March 2020, external medical practitioners provided COVID-19 training to some of St Basil's staff, including in relation to the use of PPE. On 15 March 2020, external medical practitioners provided a second COVID-19 training session to some of St Basil's staff, including in relation to the use of PPE. On 23 April 2020, external medical practitioners provided a third COVID-19 training session to some of St Basil's staff, including in relation to the use of PPE. On 5 May 2020, in response to improvements identified by the Continuous Improvement Committee, Vicky Koss, St Basil's Director of Nursing, engaged Marg Fulsom, a health and aged care management consultant from CM Consultancy, to update St Basil's infectious control plans and prepare a COVID-19 folder. On 9 May 2020, external medical practitioners provided a fourth COVID-19 training session to some of St Basil's staff, including in relation to the use of PPE. On 11 May 2020, Ms Fulsom told Ms Koss that Basil's infection control plans were up to date. On 28 May 2020, Ms Fulsom provided St Basil's with a pandemic resources folder, which required infection control training, including in PPE, at shift handovers. Ms Fulsom also collated a shorter outbreak management booklet, which addressed appropriate use of PPE. On 29 May 2020, Ms Koss placed the pandemic resources folder in the main staff room so Basil staff could access the folder. On 1 June 2020, an infection control policy outbreak management plan was put in the home's main office so staff could access the document. On 14 June 2020, external medical practitioners provided a fifth COVID-19 training session to some of St Basil's staff, including in relation to the use of PPE. Prior to the outbreak, St Basil's had a procedure for donning, doffing and using PPE. Its procedure was outlined in several documents, including A, the COVID-19 Pandemic Resources Folder, B, Infection Control Policy, Outbreak Management Plan, C, Outbreak Management Booklet, D, Nursing Home Handover Folder, E, Staff Memos, and F, Shift Handover Notes. St Basil's system of work: A, required staff to wear PPE where there was a suspected or confirmed case of COVID-19. B, provide staff with a demonstration as to the sequence and manner of donning and doffing PPE. And C, verified staff as competent in donning and doffing PPE. Between March and July 2020, St Basil's provided information, instruction and training to some of its staff in relation to, inter alia, the use of PPE. The training was delivered at sessions run by external doctors, at shift handovers and in practical sessions at the commencement of shifts. Specifically, St Basil's stated that A, between March and July 2020, infection control training was provided at handovers. B, on 4 and 15 March, 23 April, 9 May and 14 June 2020, training was provided by external doctors, Doctors Nilantha Jayarantha and Arunan Dev Apriya. And C, between 9 and 21 July 2020, training was provided at the commencement of shifts on a daily basis. Melanie Lang, Patricia Regifo Garcia, Definka Belevska, Gerarda Zahargianis and Rabina Thapa did not attend a session with the doctors or handover training related to the use of PPE. As a result of St Basil's failure to provide the necessary information, instruction and training in relation to the use of PPE, not all of its staff understood the sequence and manner of donning and doffing to control the risk of transmissions of COVID-19. Professor Shaban, the Clinical Chair, Infection Prevention and Diseases Control at the University of Sydney, provided an expert opinion in respect to the outbreak. Professor Shaban opines as follows: A, all staff that work within an aged care facility should be trained, certified and able to demonstrate the same knowledge and competency in the use and disposal of PPE. B, PPE training and assessment necessarily requires practical components. Training should include a physical demonstration of all PPE protocols and should be adapted such that they take into consideration facility-specific risks, context, infrastructure and resources. Staff competency must also be assessed practically. All staff should be able to perform PPE donning, doffing and disposal procedures with all appropriate items in the correct order and the correct situation. C, since COVID-19 is a novel disease, adequate preparation should include the dedication and timely re-education, retraining and reassessment of staff competency in infection control protocols, including all PPE-related interventions. And D, the information and training provided by St Basil's to its workers with respect to the practice of donning, doffing and use of PPE and training workers in the donning, doffing and use of PPE did not meet and fell short of the standards required for the management of SARS-CoV-2 and COVID-19. On 9 July 2020, Ms Cos was informed that a personal care assistant at St Basil's had tested positive for COVID-19. Ms Cos contacted the Commonwealth Department of Health and the Victorian Government Coronavirus Hotline. She was advised to contact the Communicable Diseases section of DHHS, which she did. At approximately 1 p.m, Ms Cos called a meeting at which she announced a positive COVID-19 case and that any concerned staff should get tested. The meeting did not include all St Basil's staff and not all those working at the time. St Basil's PCA, Patricia Rengifo Garcia, was at work but unaware of the meeting. At around 3 p.m, St Basil's PCA, Gerarda Zahargianis, commenced his shift. That evening, he worked in the hostel. Later that night, Violetta Simonovska, PCA, called Ms Velosky and informed her there was an announcement at work tested positive for COVID-19. On 10 July 2020, Mr. Me and Messrs. Velosky, Rengifo Garcia and St Basil's PCAs Definka, Belevska, Sonia Spazowski, Rubina Tharpa and Ilya Aramorovsky worked a shift at St Basil's. Both Messrs. Rengifo Garcia and Belevska recall a notice on the notice board announcing a staff member had tested positive. On 11 July 2020, Messrs. Rengifo Garcia, Spazowski and Tharpa worked shifts at St Basil's. Ms. Rengifo Garcia worked in the dementia unit. On 12 July 2020, Messrs. Rengifo Garcia, Belevska and Tharpa returned to work. On 13 July 2020, Messrs. Velosky, Belevska and Aramovsky and Bill Miltardis worked a shift at St Basil's. Ms. Velosky recalls Ms. Cos issued these directions. A. Masks and gowns were to be worn in residents' rooms. B. Masks were to be removed every 4 hours. And C. Staff were not to move between different areas of the nursing home. Similarly, Mr. Miltardis and Ms. Avramovsky recall attending a meeting at which Ms. Cos informed those gathered there had been a positive COVID-19 case. Ms. Cos told them to wear masks and how to don them, to replace their PPE every 4 hours and not to walk between wards or areas in the workplace. On 14 July 2020, Ms. Belevska worked an afternoon shift in St Basil's Hostel. She recalls being told to wear PPE and to change it after dealing with each resident. On 15 July 2020, all St Basil's employees and residents were tested for COVID-19 by government health workers. Ultimately, 45 staff members developed COVID-19. I turn to the nature and gravity of the offending. The prosecution case is that St Basil's failed to provide and maintain for its employees a working environment that was, at the relevant time, safe and without risk to health by failing to provide information, instruction and training as was necessary to enable them to perform their work in a way that was safe and without risk to health. As detailed in the particulars of the charge, the identified risk was the risk of contracting the SARS-CoV-2 virus, which could cause serious illness or death. The safety measures that would have reduced the risk included providing employees with information, instruction and training about appropriate PPE to be worn, the donning and doffing of such PPE, and what constituted a suspected or confirmed case of COVID-19 that would require the wearing of PPE. The indictment names 5 employees who were not provided with the necessary information, instruction and training. To be clear, the prosecution of St Basil's relates to the failure to adequately inform, instruct and train its employees in relation to the use of PPE, including the sequence of donning and doffing of PPE. While it is the case that many elderly residents of St Basil's contracted the SARS-CoV-2 virus and tragically many passed away, this prosecution of St Basil's is limited to its failure to adequately train the named 5 employees. In assessing the gravity of a breach under the OHSA, the Court of Appeal in Director of Public Prosecutions and Frustal Proprietary Limited summarised the guiding principles in sentencing such matters, including, relevantly, A, that an accused is punished according to the gravity of the breach of duty owed under the OHSA, not according to the result or consequences of the breach. B, the gravity of the breach is measured by 2 factors. 1, the seriousness of the breach itself, that is, the extent to which the defendant has departed from its statutory duty, and 2, the extent of risk of death or serious injury which might result from the breach, and C, that an assessment of the extent of the risk itself involves consideration of 2 factors. 1, the likelihood of the occurrence of an event as a result of the breach, such as the event that occurred in the particular case, endangering the safety of employees or others, and 2, the potential gravity of the consequences of such an event, in particular, whether there is a risk of death or serious injury." End quote. It was submitted on behalf of St Basil's that the offending falls towards the lower end of the range, in that the extent of St Basil's departure from their statutory duty is slight, and that the extent of the risk in this instance was low. St Basil's submitted that the evidence reveals that the company was cognisant of the need to protect its staff and the residents from the risks associated with COVID-19, as detailed in extensive written submissions filed on the plea. For example, through the charge period, St Basil's introduced additional training on the use of PPE and further education in relation to infection control and spot checks. Further, on 30 June 2020, infection prevention and control outreach nurses attended the facility and found St Basil's to be appropriately prepared for the COVID-19 outbreaks with appropriate infection and control practices. In summary, it was submitted that St Basil's had appropriate systems in place and was taking active steps to ensure the staff and residents were protected from outbreaks of COVID-19. The prosecution accept that St Basil's had in place at the relevant time a system of work that required staff to wear PPE where there was a suspected or confirmed case of COVID-19, and that St Basil's provided staff with training in relation to donning and doffing of PPE. The prosecution case, however, is that such information, instruction and training was provided to all but 5 of its employees. In simple terms, even if there was in place a system that provided appropriate training in relation to the use of PPE, it was inadequate, as some employees were not trained, thereby placing other employees at risk of serious injury or death. The prosecution submitted that the offending is serious, as St Basil's conduct involved a clear departure from acceptable safety standards, relying on the evidence of Professor Shaban that, quote, the risk of infection in circumstances where there is inappropriate or insufficient use of PPE within the hierarchy of control is certain, end quote. The prosecution submitted that in the circumstances, St Basil's knew of the risk and the suitable available measures, but failed to provide all its employees with the necessary training prior to the outbreak. Further, that once it was known that an employee had tested positive, it did not ensure at the time that all staff had received the appropriate and necessary training. In my view, St Basil's was well aware of the risks associated with the COVID-19 outbreak and the measures that would be required to maintain a safe working environment. I also accept that it had in place infection control practices. Nonetheless, it is well established there is no benefit in having a system in place unless it is appropriately monitored and implemented. Here, there were weaknesses in the system that led to 5 of its employees not receiving the adequate training required, giving rise to the identified risks. As noted in the Queen and Commercial Industrial Construction Group Proprietary Limited, quote, the formal adoption of a satisfactory safety management system will not have the beneficial effects intended unless it is accompanied by the employer's active implementation of the system in the workplace. The employer's duty will not be discharged simply by creating a safe system of work. The obligation requires the employer to ensure that procedures and instructions are actively and positively complied with by employees. Not only must employees be appropriately trained, but there must be ongoing supervision and compliance audits to ensure that the system is being applied in practice. Employee compliance with the safe system of work must be constantly monitored by the employer, end quote. In my view, in all the circumstances, St Basil's departure from its duty in this instance represents a relatively serious breach. St Basil's is a residential aged care facility in Fawkner, Victoria. It is a not-for-profit organisation operating under the auspice of the Greek Orthodox Archdiocese of Australia. It is a registered charity, and all income it earns must be applied solely towards the promotion of the charitable purposes of the company. Its directors volunteer their time and are not paid directors' fees. St Basil's currently employs 100 staff and accommodates 77 residents. At the time of the outbreak in July 2020, St Basil's was a full paper-based facility with limited digital infrastructure. It has since introduced digital monitoring and record-keeping systems, which has led to an improvement in governance, infection prevention and control, and regulatory compliance. The company has also introduced infection prevention and control lead positions, or IPC lead, which require considerable training and accreditation. There are 2 IPC lead positions supervised by the facility manager. Further, the company has engaged an education assistant to assist staff to complete the required training. The new structure that has been developed and enhanced since the outbreak in 2020 has the purpose of ensuring that the failures identified in 2020 cannot occur under the current governance. In 2022, the company achieved an 18-month accreditation from the Aged Care Quality and Safety Commission. In September 2023, ACQSC conducted a further review of St Basil's operations and granted a full 3-year re-accreditation with no risks identified. Turning to sentencing considerations and firstly matters in litigation. Mr O'Brien, who appeared on behalf of St Basil's, outlined a number of matters to be taken into account in mitigation. First and foremost is the plea of guilty. This matter has had a long investigative and procedural history. The offending occurred in 2020 and the company was charged some 2 years later. There were significant delays due to a lengthy coronial inquest and the contested committal was not conducted until February 2024. The matter then had a number of administrative hearings in this court with a tentative trial date in May 2026. The trial was estimated to take 4 weeks. The matter came before me for a sentence indication hearing, with the indication being handed down on 2 December 2025. On 12 December 2025, St Basil's accepted the indication and the company was arraigned on 2 March 2026, pleading guilty. The plea has considerable utilitarian value as it has spared the resources and time required for a trial. I therefore take the company's acceptance of responsibility and its willingness to facilitate the course of justice into account. I take into account the delay in this matter. As noted above, this case has had a long procedural history resulting in a delay of approximately 5 years between the offending and the sentence indication hearing, including a delay of 2 years between the offending and charges being laid. In my view, the 2 limbs of the principle of delay can be given weight. First, delay of this magnitude has meant that the prolonged criminal process has been an ongoing stress and burden for the company and its employees. Secondly, the company has, in the intervening period, upgraded and improved its training and auditing systems, and it has not been the subject of any further criticism or scrutiny. It was admitted that the company has been subjected to a form of extracurrial punishment. While many COVID-19 outbreaks occurred in numerous aged care facilities in Victoria, the outbreak at St Basil's became the focus of enormous public attention through the media. Further, it is the only residential aged care facility to be sentenced in respect of its response to the pandemic. In my view, some weight can be given to the fact that the company has been exposed to a degree of public opprobrium. Turning to other sentencing considerations. In cases involving breaches of the OHSA, general deterrence is the predominant sentencing consideration. As noted in the Director of Public Prosecutions and Vibropile Australia Proprietary Limited, quote, "The sentences imposed need to draw attention to the importance of workplace safety and to send a message to employers that failure to eliminate or mitigate risks will attract significant punishment." As to specific deterrence, I take into account that the company comes before the court with no prior convictions and is otherwise a company of good character. It is registered as a public benefit institution and it is a registered charity established specifically for the provision of aged care. As such, all income it earns is applied towards the promotion of the charitable purposes of the company and its directors are volunteers. As outlined above, it is also taking considerable steps to improve its readiness for any future events or outbreaks, including continued PPE competency training to all staff together with structured audits and monitoring via digital monitoring and record-keeping systems. In the circumstances, in my view, specific deterrence need not be given weight in the circumstances. It was submitted that a conviction should not be recorded. Mr O'Brien pointed to the substantial efforts made by the company to protect its employees from the risk of COVID-19, the fact that it is a not-for-profit institution and, that was impacted financially and reputationally as a result of the outbreak, and that it comes before the court with no prior criminal history. While these are matters I take into account, I must also take into account the nature and seriousness of the offence. In my view, the seriousness of the offending, together with the weight to be placed on general deterrence, warrants the recording of a conviction. Finally, the prosecution and defendant company each provided the court with comparable cases, which I have taken into account. As is well settled, only limited assistance can be derived from comparative cases. However, while they can inform the instinctive synthesis, each case must be assessed on its own unique circumstances. In the circumstances, St Basil's Home for the Aged in Victoria is sentenced as follows. On charge 1, failing to ensure, as a person who had, to an extent, the management and control... Sorry, that's not the correct charge. I'll just correct that. On charge 1, failing to provide and maintain for employees, as far as was reasonably practicable, a working environment that was safe and without risk to health, St Basil's Homes for the Aged in Victoria is convicted and fined $150,000. Pursuant to Section 6AAA of the Sentencing Act 1991, if not for the plea of guilty, I would have fined the company $250,000 with conviction.